Hello and welcome to the K-1 Fiancee Visa Petition Self-Assessment video brought to you by ImmigrationEase.com, where affordable, professional quality immigration case preparation is made as easy as 1, 2, 3. Before we dive into the assessment, please click the pause button to read our disclaimer and then resume the video as soon as you're done. So, you're interested in applying for a K-1 Fiancee visa. Well, step 1 in the process is to find out if you qualify for the visa in the first place. So the first question we need to ask ourselves is the petitioner a U.S. citizen? Note that in order to qualify for a K-1 visa, the petitioner must be a U.S. citizen. If you are a permanent resident, you should apply for naturalization to citizenship before you can file a petition to sponsor a K-1 visa for your fiancé. Question number 2. Are both members of the couple legally able to marry? Legal ability to marry depends on the state where you're getting married. So you must first of all be of marriageable age in the state where you will be getting married. And secondly, all prior marriages of both the spouse and the K-1 visa applicant must have been properly terminated. And finally, note that in some cultures, first cousin marriage may be acceptable, but there are state laws that prohibit such marriages. So you have to be mindful of that if you're in such a state. Question number 3. Do you intend to marry within 90 days of the K-1 applicant's entry to the United States? Intent to marry within 90 days is required, but once the fiancé enters, failure to get married within 90 days does not eliminate the opportunity to later get married and file for adjustment of status. But your K-1 status will expire. Of course, to avoid any complications, it's best to abide by the 90-day rule. And of course, when you do file the petition, you must demonstrate intent and express intent to marry within 90 days. Question number 4. Can you prove that you personally met within the past 2 years? So as for the requirement of having personally met the fiancé within the past 2 years, there are exceptions. If the petitioner can prove that there are hardships which make it difficult to personally meet, the requirement of having met personally can be waived. But beware that it's very difficult to establish this, and there is a very strong burden of proof that you're going to have to demonstrate. So you'd better have met in person. It's very important. Other exceptions to not meeting and still being qualified for the K-1 would be customary, cultural, or social practices which have been restricted, which restrict meeting before marriage, that is. And again, you need to be able to prove this and document it. And of course, you have to prove that if you have met, you should be able to demonstrate that through photos, or if not photos, visas, in your passport, showing that you traveled to the foreign national's country, or the foreign fiancé came to the United States to visit you. So if you've answered yes to all of the above questions, and assuming that you have no grounds of inadmissibility, and we're talking about the beneficiary of the K-1, the beneficiary should be eligible to apply for the K-1 fiancé visa. This completes the K-1 fiancé visa petition assessment. If you have concluded that you qualify for a K-1 fiancé visa and you wish to prepare the application, we recommend that you purchase our K-1 fiancé visa do-it-yourself toolkit. Since it's an audio-visual guide where we include or direct you to all of the required materials to prepare your application, you'll never miss a step or be confused. We are confident that you will find our kits to be the easiest to follow and most effective kits available on the market. However, if you are still unsure as to whether you may qualify for a K-1 fiancé visa and you still have more questions, then we recommend that you arrange a consultation with an immigration attorney by calling the phone number listed below.